Some still are. We salute them, and we salute those who went before them for running towards danger in order to secure peace. Madam President, I suggest the absence of a quorum.
The clerk will call the roll.
Mr. Akaka.
The senator from Ohio is recognized.
Ask the quorum be vitiated.
Without objection, so ordered.
On behalf of Senator Leahy, I ask unanimous consent that Michelle Lacko, a fellow on the Senate Judiciary Committee, be granted Senate floor privileges for the duration of debate on S-3240, the Agricultural Reform, Food and Jobs Act of 2012.
Without objection, so ordered.
And I suggest for
The clerk will call the roll.
Mr. Akaka.
In about an hour from now, at 5:30 Eastern, the Senate is scheduled to vote on a judicial nomination for the Northern District of Ohio. The pending legislation on the floor right now is the Farm Bill, which includes subsidies for farmers and nutrition and food programs, including food stamps. Some of our live coverage tomorrow, Attorney General Eric Holder will testify before the House Judiciary Committee about operations at the Justice Department. That'll be live online at 9:30 a.m. Eastern at cspan.org. And also, Fed Chairman Ben Bernanke will talk about the economic outlook at a hearing of the Joint Economic Committee. Our live coverage of that at 10 a.m. Eastern on C-SPAN 3.
Senator from Iowa is recognized.
I ask the calling of the quorum be suspended.
Without objection, so ordered.
Today, the Senate turns to another judicial nomination, Jeffrey J. Helmick, District Judge, Northern District, Ohio. I want to tell the Senate why I oppose the nomination and urge all senators to do likewise. We continue to confirm the President's nominees at a very brisk pace. Just 2 days ago, we confirmed the 147th judicial nominee of this President to district and circuit courts. Let me put that in perspective for my colleagues. We also have confirmed 2 Supreme Court nominees during President Obama's term. The last time the Senate confirmed 2 Supreme Court nominees was during President Bush's second term. During President Bush's entire second term, the Senate confirmed a total of only 120 district and circuit court nominees. We have already confirmed 27 more nominees for President Obama than we did for President Bush in a similar period of time. And this is in a presidential election year, typically a time when judicial confirmations are limited to consensus nominees. Yet, here we are, considering a controversial nomination. Perhaps the Senate could better spend this time working on critical issues facing our nation, such as our massive debt, intolerable deficit spending, an anemic economy, unacceptable unemployment levels, high energy costs, and national security issues. The advice and consent function of the Senate is a critical step in the appointment of federal judges. In the Federalist Paper, number 76, Alexander Hamilton wrote this, quote, "To what purpose, then, require the cooperation of the Senate?" I answer, meaning Alexander Hamilton answering, that the, quote, "that the necessity of their concurrence would have a powerful, though in general, a silent operation. It would be an excellent check upon a spirit of favoritism in the President and would tend greatly to prevent the appointment of unfit characters from state prejudice, from family connections, from personal attention, or from a view to popularity. End of Alexander Hamilton's statement in Federalist Paper 76. In other words, the Senate has a role in preventing the appointment of judges that are unfit characters or political favors of any president and of those who are not qualified to serve as federal judges. What did our current president, then Senator Obama, say about this duty? He stated, quote, "There are some who believe that the president, having won the election, should have the complete authority to appoint his nominee, and the Senate should only examine whether or not the justice is intellectually capable and an all-around nice guy. That once you get beyond intellect and personal character, there should be no further question whether the judge should be confirmed." I disagree with this view, Senator Obama said, then Senator Obama said. I believe firmly that the Constitution calls for the Senate to advise and consent. I believe that it calls for meaningful advice and consent that includes an examination of the judge's philosophy, ideology, and record, end of quote, of then Senator Obama. Mr. President, our inquiry of the qualifications of nominees must be more than intelligence, a pleasant personality, or a prestigious clerkship. At the beginning of this Congress, I articulated my standards for judicial nominees. I want to ensure that the men and women who are appointed to a lifetime position in the federal judiciary are qualified to serve. Factors I consider important include intellectual ability, respect for the Constitution, fidelity to the law, personal integrity, appropriate judicial temperament, and professional competence. In applying these standards, I have demonstrated good faith in ensuring fair consideration of judicial nominees. I have worked with the majority to confirm consensus nominees. However, as I have stated more than once, the Senate must not place quantity confirmed over quality confirmed. These lifetime appointments are too important to the federal judiciary and the American people to simply rubber stamp them. This is not a pro forma process that we're engaged in. Last year, I became increasingly concerned about some of the judicial nominees being sent to the Senate by this administration. In a few individual cases, it was very troublesome. Mr. Helmick's nomination fell into that category. When I apply the standard that I mentioned and the standards which then Senator Obama laid out, or the standards expressed when I apply the standards I mentioned, or the standards which then Senator Obama laid out, or the standards expressed in the Federalist Papers, I reach the same conclusion. In my judgment, Mr. Helmick fails to meet the required standard and should not be confirmed. The Senate process for reviewing the professional qualifications, temperament, and background and character is a long and thorough process. In Mr. Helmick's case, there were some issues that needed to be fully examined. At the conclusion of that lengthy process, a substantial majority of my political party, the Republicans, on the Judiciary Committee, determined that this nomination should not be reported to the Senate. Nevertheless, we now have the nomination before us. Even so, there are reasons sufficient to oppose the nomination. In 2000, Mr. Helmick faced disciplinary action for failing to comply with a court-issued subpoena. He refused to turn over an incriminating letter signed by a former client in the same case, which contained threats to a state's witness. A grand jury issued a subpoena to obtain the letter, but Mr. Helmick refused to appear before the grand jury. The trial court found him in contempt of court. Mr. Helmick appealed, which caused the contempt sanction to be stayed. A three-judge panel of the Ohio Court of Appeals unanimously held that he was required to turn over the letter. Mr. Helmick then appealed to the Ohio Supreme Court, which held that he must comply with the subpoena, although they lifted the contempt citation. Supreme Court of Ohio stated that Mr. Helmick's concerns regarding the attorney-client privilege were not enough to, quote, override the public interest in maintaining public safety and promoting the administration of justice. I do not think that we need to confirm to the bench individuals that are willing to put private interest over the public interest in the administration of justice. I am concerned about Mr. Helmick's view on national security as evidenced by his handling of terrorism cases as a defense attorney. In looking at the arguments that he has made in court representing terrorists, I'm concerned that he may believe terrorism cases are less serious than other criminal cases, and that in turn causes some concern about how he might handle terrorism cases that may come before him if confirmed. For example, he represented the terrorist Wasim Mazloum. This terrorist was convicted by a jury, a conspiracy to kill U.S. troops overseas, and of providing material support for terrorists. Those are very serious crimes. According to the sentencing guidelines, Mazloum deserved life in prison. Mr. Helmick argued, quote, that perhaps the life sentence that was called for in the advisory sentencing guidelines was too severe or too harsh. In the end, this terrorist did not receive a life sentence. Rather, he received only an 8-year sentence, hardly a punishment or deterrent. For these reasons and others, I will vote no on this nomination and urge my colleagues to do likewise. I yield the floor. And I suggest the absence of a quorum.
The clerk will call the roll.
Mr. Akaka.
A little bit more about the farm bill that the Senate is working on. Earlier today, Majority Leader Harry Reid said that the leadership is trying to reach an agreement to proceed to the measure, and otherwise the chamber would take a cloture vote tomorrow. Debbie Stabenow, who is the chairman of the Senate Agriculture Committee, she wrote the bill, said that she's confident that she has the 60 votes needed to formally begin debate on the bill if opponents try to block it.
Madam President.
The senator from Vermont is recognized.
Madam President, I ask consent to call the quorum be dispensed with.
Without objection, so ordered.
Madam President, I understand I have time remaining.
The majority has 17 minutes and 10 seconds.
Madam President, I will use part of that to refer to the Farm Bill, and I'd ask that consent that the part, and speaking of the Farm Bill, be appear in the debate on proceedings to that matter.
Without objection, so ordered.
And first, I thank the chairwoman, Senator Stabenow, the ranking member, Senator Roberts, for working together to advance a bipartisan farm bill, one that can pass Senate and become law this year. I know, having been and served in the position both as chairman and as ranking member with Senator Lugar, I know how hard it is to get consensus, but when you make it as a bipartisan consensus, as Senator Lugar and I did, it is far more apt to pass the bill. Some ask why we have to do this. Well, we have to do it because the current farm bill expires at the end of September. Our dairy farmers have a serious matter that if it's not addressed by August 31st, they're left without a vital safety net. Now, I know that not all senators come from farm country, but those that do, like the distinguished presiding officer, have a great deal at stake in this bill. But it's also a bill that affects every state, farm or otherwise, touches the lives of every American through the healthy food in our kitchen tables or our children's Clean water that's the result of critical conservation programs. Rural businesses on Main Street receiving assistance from USDA. New energy products resulting from research supporting this bill, and the benefits we all get from our local farm system. So farming is part of our national security. Keeping American agriculture strong and vibrant is at the core of this bill. Now, is it the farm bill that I would have drafted? No. I could go around every one of the other 99 senators. It's not exactly the one any one of us would. But to get a farm bill, it always has to be a compromise. And I'll continue to work with the chairwoman and the ranking member to make it the best one possible. I am pleased the farm bill includes a major dairy reform proposal. I know that both our producers and consumers will be helped to move away from the dangerous roller coaster of price swings. Farm bill scraps outdated price supports. The Milk Income Loss Contract Program has a new risk management plan that protects farm income when margins shrink dangerously. And it does it at a lower cost than the program it replaces. Dairy is Vermont's single most important agriculture community. If any senator has a concern about the dairy reforms in this bill, I'd be glad to discuss them with him. There's been a lot of misinformation about the provisions, and I welcome an opportunity to eliminate any confusion. So let us work together on this. We can come together in a bipartisan way, just as we did on the Senate Agriculture Committee. The Farm Bill represents an investment in American agriculture. It will benefit our producers, our rural communities, our Main Street businesses, taxpayers and consumers, and the neediest among us. It deserves our attention, and I'd ask consent that my full statement be made part of the record.
Without objection, so ordered.
And, Madam President, let me refer to the issue before us, the nomination before us, and I know the distinguished senior senator from Ohio will speak again afterward. Jeffrey Helmick was rated well qualified by a substantial majority of the ABA Standing Committee of the Federal Judiciary. That's the highest rating any nominee can get. In his 22-year legal career as a litigator in private practice, he's tried approximately 40 cases to verdict or judgment. Most lawyers in practice today do not begin to have that experience. And currently a principal at his law firm, he has the strong support of his home state senators, one a Democrat, one a Republican, who has spoken in support of his nomination. And he was voted out of the Judiciary Committee almost 3 months ago by a bipartisan majority, Mr. President. So given his distinguished record in private practice, his bipartisan support, I trust he'll be confirmed. Now, some have chosen to criticize him for his role as a court-appointed defense attorney. Well, anybody who make that criticism actually obviously does not understand how our justice system works. Our legal adversary system, our legal system is an adversary system, is predicated upon legal advocacy for both sides. That's what Mr. Helmick did at the request of the court. It really shows a misunderstanding of why we have the best legal system in the world if people don't understand that both sides are supposed to be adequately represented. And no nominee should be disqualified for representing clients, especially when the courts ask them to. At his confirmation hearing to become Chief Justice of the United States, John Roberts made this point, quote, "It's a tradition of the American bar that goes back before the founding of the country. The lawyers are not identified with the position of their clients." Most famous example probably is John Adams, who represented the British soldiers charged in the Boston Massacre. He did that for a reason, because he wanted to show that the revolution in which he was involved was not about overturning the rule of law is about vindicating the rule of law. And Mr. President, just think about that. Here's a man who became President of the United States, a man who was helping to lead the effort to separate us from the rule of Great Britain, but he was willing to defend British soldiers who were charged with the massacre of the people who wanted to be free of Great Britain. Our founders thought, and this is what every lawyer would think, that they were not being given their rights under the British system which they were entitled, and by representing the British soldiers, he helped show that what they were about was defending the rule of law, not undermining it. And that principle, that you don't identify the lawyer with the particular views of the client or the views that the lawyer advances on behalf of the client, is critical to the fair administration of justice. That last part was a quote from Justice Roberts, and I'd ask consent that Justice Roberts' whole quote be put in its entirety.
Without objection.
Now, Mr. Helmick was appointed by the court to represent a defendant. He had the ethical obligation to advocate zealously for that client. That's what he did. He shouldn't be punished for doing that, and it really does not do credit to the United States of America or to the United States Senate to criticize somebody, well, court appoints to defend somebody, and then criticize them for doing it. It is what keeps us all free. In fact, there has apparently been an objection to Mr. Helmick's handling of an ethical dilemma when he refused to disclose a client's secret. I don't know why they object to that, because the Ohio Court of Appeals, who heard the case, stated that Mr. Helmick should be commended for his professional ethical behavior in a very difficult situation. In addition, though, you had divided Ohio Supreme Court, 4-3 decision, who then ordered the disclosure of this letter, agreed unanimously with Mr. Helmick the letter was the client's secret, and said he acted in good faith. Well, come on. When you represent a client, you act within the ethical rules, which he did. You act with zealousness, which he did. And you uphold the kind of representation we expect that John Adams showed us after the Boston Massacre, that John Roberts advocated for when he spoke of John Roberts, and that this nominee did. Mr. President, I ask consent to my full statement made part of the record, and I yield the balance of my time to the distinguished senior senator from Ohio.
Without objection, the full statement will be made a part of the record, and the distinguished senator from Ohio is recognized.
Thank you, Mr. President. I appreciate the kind words and the insight from Chairman Leahy and his leadership on trying to speed up the confirmation process and a whole host of judges. I have a lot of respect for my colleague from Iowa, but I take exception with a couple of things he said. One, he compared the number of nominations during the second Bush 4 years with the first 4 Obama years, saying that the Senate was more cooperative now than it was then. Clearly, it was apples and oranges, and we know almost any school kid in America now knows the dysfunction of the United States Senate in terms of the minority party blocking all kinds of things, from medium to low-level federal appointments to the president's executive, to the executive branch, to district court judges, to legislation. So I think that Senator Leahy has addressed that very aptly, and I don't need to go into detail there. Senator Leahy also has spoken to the 2 public disagreements, the 2 criticisms, shallow and vacuous that they are, of Jeffrey Helmick. The one on terrorists, representing terrorists. I'm not a lawyer, but I know that when a federal judge asks a lawyer to represent somebody, the lawyer does it, as Jeffrey Helmick did. And as Senator Leahy said on the ethics issue, the Ohio Court of Appeals said that Mr. Helmick should be commended. The Supreme Court agreed unanimously that that the letter they talked about was a client secret and that Mr. Helmick acted in good faith. So those criticisms don't really stand the test of time in that way. I'll just close with this, Mr. President, and again thanking Senator Leahy and the Judiciary Committee for moving as quickly as they could move in a difficult time with sometimes Senate dysfunction and the minority party blocking or slow-walking so many of these nominees. Jeffrey Helmick has been supported by a bipartisan, rigorous committee of 17 coming from Southern Ohio, helping to choose nominees for the Northern District of Ohio. I spoke personally with all but one or two of those 17 Republicans and Democrats around whom consensus formed in support of Jeffrey Helmick. They think he's an outstanding lawyer, jurist, potential federal judge. The other federal judges in the western region, of the western area of the Northern District Court in Ohio, out of Toledo, including a judge nominated by President George W. Bush, enthusiastically support Jeffrey Helmick. So in other words, Senator Grassley said he was a controversial nominee. He's only controversial in the Senate Judiciary Committee and among some of my colleagues. He's not controversial in Ohio, where they know Jeffrey Helmick the best. He's not controversial in the Toledo Bar Association. He's not controversial among federal judges in Toledo. He's not controversial among people who know Jeffrey Helmick, who have watched him personally in his service to community and who have watched him professionally in the way that he does his job as a lawyer in Toledo, Ohio, in Northwest Ohio, in federal court or in state courts. So the fact is he's not a controversial nominee. He's only a controversial nominee in the United States Senate and in some places in Washington, D.C. But we know he's qualified. We know he's ready to serve. I ask my colleagues to vote today to confirm Jeffrey Helmick to the United States Federal Court, Northern District of Ohio. Mr. President, I yield the floor.
The Senator from Vermont.
President, I yield back the remainder of the time and ask for the yeas and nays.
Is there a sufficient second? There appears to be. The clerk will call the roll.
Mr. Akaka, Mr. Alexander, Ms. Ayotte, Mr. Barrasso, Mr. Baucus, Mr. Begich, Mr. Bennett, Mr. Bingaman, Mr. Blumenthal, Mr. Blunt, Mr. Bozeman, Mrs. Boxer, Mr. Brown of Massachusetts, Mr. Brown of Ohio, Mr. Burr, Ms. Cantwell, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Coates, Mr. Coburn, Mr. Cochran, Ms. Collins, Mr. Conrad, Mr. Coons, Mr. Corker, Mr. Cornyn, Mr. Crapo, Mr. Dement, Mr. Durbin, Mr. Enzi, Mrs. Feinstein, Mr. Franken, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mrs. Hagan, Mr. Harkin, Mr. Hatch, Mr. Heller, Mr. Hoven, Mrs. Hutchison, Mr. Inhofe, Mr. Inouye, Mr. Isaacson, Mr. Johans, Mr. Johnson of Wisconsin, Mr. Johnson of South Dakota, Mr. Carey, Mr. Kirk, Ms. Klobuchar, Mr. Cole, Mr. Kyle, Ms. Landrieu, Mr. Lautenberg, Mr. Leahy, Mr. Lee, Mr. Levin, Mr. Lieberman, Mr. Lugar, Mr. Manchin, Mr. McCain, Mrs. McCaskill, Mr. McConnell, Mr. Menendez, Mr. Merkley, Ms. Mikulski, Mr. Moran, Ms. Murkowski, Mrs. Murray, Mr. Nelson of Nebraska, Mr. Nelson of Florida, Mr. Paul, Mr. Portman, Mr. Pryor, Mr. Reed of Rhode Island, Mr. Reed of Nevada, Mr. Risch, Mr. Roberts, Mr. Rockefeller, Mr. Rubio, Mr. Sanders, Mr. Schumer, Mr. Sessions, Mrs. Shaheen, Mr. Shelby, Ms. Snow, Ms. Stabenow, Mr. Tester, Mr. Thune, Mr. Toomey, Mr. Udall of Colorado, Mr. Udall of New Mexico, Mr. Vitter, Mr. Warner, Mr. Webb, Mr. Whitehouse, Mr. Wicker, Mr. Wyden. Senators voting in the affirmative: Brown of Ohio, Collins, Leahy, Menendez, Stabenow, and Whitehouse. Senators voting in the negative: Cochran, Kyle, and Wicker. Mrs. Shaheen, aye. Mr. Grassley. Mr. Grassley, no. Mrs. Gillibrand. Mrs. Gillibrand, aye. Mr. Portman. Mr. Portman, aye. Mr. Inhofe. Mr. Inhofe, no. Mrs. Feinstein. Mrs. Feinstein, aye. Mr. Tester. Mr. Tester, aye. Mr. McConnell. Mr. McConnell, no. Mr. Webb. Mr. Webb, aye. Mr. Brown of Massachusetts, aye. Mr. Cole. Mr. Cole, aye. Mr. Alexander. Mr. Alexander, aye. Mr. Reed. Mr. Reed of Rhode Island, aye. Mr. Nelson. Mr. Nelson of Florida, aye. Mr. Inouye. Mr. Inouye, aye. Mr. Isaacson. Mr. Isaacson, no. Mr. Johnson. Mr. Johnson of South Dakota, aye. Mr. Thune. Mr. Thune, no. Mr. Blumenthal. Mr. Blumenthal, aye. Mr. Roberts. Mr. Roberts, no. Ms. Ayotte. Ms. Ayotte, no. Mr. Durbin. Mr. Durbin, aye. Ms. Mikulski. Ms. Mikulski, aye. Mrs. Hagan. Mrs. Hagan, aye. Mr. Franken. Mr. Franken, aye. Mr. Lugar. Mr. Lugar, aye. Mr. Johnson. Mr. Johnson of Wisconsin, no. Mr. Lee. Mr. Lee, no. Mr. Paul. Mr. Paul, no. Ms. Klobuchar. Ms. Klobuchar, aye. Mr. McCain. Mr. McCain, no. Mr. Corker. Mr. Corker, aye.
As if you have nothing else.
Mr. Lautenberg. Mr. Lautenberg, aye. Mr. Hatch. Mr. Hatch, no. Mr. Carey. Mr. Carey, aye. Mr. Moran. Mr. Moran, no. Mrs. Murray. Mrs. Murray, aye. Mr. Coburn. Mr. Coburn, no. Mr. Enzi. Mr. Enzi, no. Mr. Shelby. Mr. Shelby, no. Ms. Klobuchar. Ms. Klobuchar, aye. Mr. Crapo. Mr. Crapo, no. Mr. Coates. Mr. Coates, no. Mr. DeMent. Mr. DeMent, no. Mr. Nelson. Mr. Nelson of Nebraska, aye. Mr. Cornyn. Mr. Cornyn, no. Mrs. Boxer. Mrs. Boxer, aye. Mr. Cardin. Mr. Cardin, aye. Mr. Sessions. Mr. Sessions, no. Mr. Johans. Mr. Johans, no. Mr. Barrasso. Mr. Barrasso, no. Mr. Manchin. Mr. Manchin, aye. Mr. Carper. Mr. Carper, aye. Mr. Chambliss. Mr. Chambliss, no. Mr. Levin. Mr. Levin, aye. Mr. Wyden. Mr. Wyden, aye. Mr. Bingaman, aye. Mr. Toomey. Mr. Toomey, no. Mr. Harkin. Mr. Harkin, aye. Mr. Begich, aye. Mr. Blunt, no. Mr. Baucus. Mr. Baucus, aye. Mr. Reed. Mr. Reed of Nevada, aye. Mr. Coons. Mr. Coons, aye. Ms. Landrieu. Ms. Landrieu, aye. Mr. Akaka. Mr. Akaka, aye. Mr. Graham. Mr. Graham, aye. Mrs. Hutchison. Mrs. Hutchison, no. Mr. Warner. Mr. Warner, aye. Mr. Bennett. Mr. Bennett, aye. Mr. Hoven, no. Mr. Bozeman. Mr. Bozeman, no. Mr. Burr. Mr. Burr, no. Mr. Casey. Mr. Casey, aye. Mr. Risch. Mr. Risch, no. Mr. Udall. Mr. Udall of New Mexico, aye. Mr. Lieberman. Mr. Lieberman, aye. Ms. Snow, aye. Mr. Udall of Colorado, aye. Cantwell. Ms. Cantwell, aye. Mr. Rubio. Mr. Rubio, no. Mr. Sanders. Mr. Sanders, aye. Mr. Conrad. Mr. Conrad, aye. Mr. Heller. Mr. Heller, no. Murkowski. Mr. Merkley, aye. Mr. Pryor. Mr. Pryor, aye. Mrs. McCaskill. Mrs. McCaskill, aye. Mr. Schumer. Mr. Schumer. Mr. Schumer, aye. Mr. Rockefeller. Mr. Rockefeller, aye. Ms. Murkowski. Ms. Murkowski, aye.